DNA evidence is something that's been a pivotal part thus far in the case against Bryan Kohberger. And, well, some of that DNA evidence going over to the defense. Recently, Idaho prosecutors have submitted the disputed DNA evidence to the court in the case of Bryan Kohberger, who's accused, of course, of murdering those four University of Idaho students back in 2022. This is the IGG evidence, the investigative genetic genealogy. The police used IgG evidence to generate leads, but they say they did not use it to obtain any sort of warrants. The DNA sample on the knife sheath found at the crime scene was allegedly matched to Kohberger through a cheek swab. Here to join me and help kind of break down what this all means, Neama Rahmani, former federal prosecutor. Uh, Neema, what does this all mean? This is evidence that we've heard is not going to be used actually in the trial itself, but of course in discovery, fair, I guess, to give it over to the defense of Kohberger. Why is this such a weird sticking point? Why is there a lot of attention on this specific piece of evidence right now?
Well, Tony, a lot of people have a problem with IgG because it can connect mine or your DNA that really isn't in the system because we have never committed a crime, but maybe one of our family members has. And that familial DNA gives law enforcement a huge advantage because they may have a DNA sample like they had in this case, and it might not be a match to anyone. But if they get to that next level, the family members, then all of a sudden they can say, well, maybe Tony or Nima's uncle had a problem with the law a few years back, and they can get closer to the person that they're after.
So what is so wrong with that if in fact it does actually lead you to a criminal or someone who has done something wrong that they are trying to track down?
Well, a lot of privacy advocates and civil libertarians think that it's unfair for law enforcement to be able to track someone down based on their DNA when they've done nothing wrong and they haven't had to give a sample. Now, of course, a judge can always order a DNA sample, and that's what we saw in the Kohberger case. But one, I think law enforcement doesn't want the public necessarily to know about this because it's such a powerful investigative tool. I think it helped catch the Golden State Killer, for instance, and Gone Girl Sherry Papini are two recent cases here in California that come to mind. But when they're really at a dead end, this type of analysis can lead to really sort of fruitful conclusions. And it's really so powerful. And obviously, each state is different. At least here in my home state of California, there's a special board that has to approve these types of requests. Law enforcement doesn't have access to everyone's familial DNA. The California Attorney General's office has to go to a very specific board that authorizes it in particular unique circumstances.
The fact that this is something new that's being used as a tool, is that why there's so much attention on it right now and so much, I guess, caution on it with some groups, considering it is a very valuable tool. It is something that can lead to arrests. It can lead to people who have done wrong, as long as it's not going down a route of we're incriminating people who are that are wrongly accused, because obviously the DNA is very, very specific. So if it is in fact a family member, but it's not you, where does the issue come in? Because we are using someone else's DNA as part of the path to get from point A to point B, that point A was someone else who didn't do anything wrong, but that in fact led us to B.
Yeah, I mean, that's part of it. So obviously, we would talk about the privacy concerns in the public and members of the legislature that may not like this, but there's another Fourth Amendment concern, right? Where someone was compelled to provide DNA for some reason, and because of that individual, they may have waived their Fourth Amendment rights, or you might not have Fourth Amendment rights, right? So if you've been convicted, for instance, and you're on probation, right, you might not have a Fourth Amendment right to prevent a police officer from patting you down or even searching you because you're a convicted felon, for instance. But someone who hasn't gone through those procedural safeguards, someone that hasn't been arrested or convicted, may not necessarily have waived those rights. So it's a question of privacy. It's a question of constitutional rights in the Fourth Amendment. And really the final issue, which is the one we're really dealing with in this case, is discovery. So, I mean, setting all this aside, the state of Idaho is saying, well, listen, even though we did this, we admit to doing it, we didn't use any of this evidence in support of our search warrant and our arrest warrant to get probable cause, right? Our probable cause is based on, XYZ. And us following Kohberger to his house in Pennsylvania and getting his father's DNA and doing that type of match, right? So the question is, especially a case like this, likely death penalty case, there's going to be those mandatory state appeals. Regardless of what's been done, I really like the prosecution to produce evidence and discovery.
Mhm.
I don't like it when they hold things back because you're creating a potential unnecessary appellate issue. Even though I get it, law enforcement, they don't want to tip their hands and let, especially pretty sophisticated folks like Bryan Kohberger, who are, PhD students, know what investigative tools they have in their disposal.
So, could this in any way affect the DNA that was obtained through the other means, going to the home, getting the trash, and tracing the DNA from his father back to Bryan Kohberger? Uh, could this affect that at all, considering we're talking two different types of DNA and two different ways of gathering it? Or is this exactly what you just said? It's just let's throw it out there, you can have it, and then it negates any sort of appellate issues down the road.
I think the state should discover it because it's a scientific test related to the defendant. So that's a separate basis. But I don't think it's going to affect the case. And this is why. When you throw something out, that trash, you don't have any Fourth Amendment protection anymore, right?
Mhm.
It's been discarded. It's in the public domain. You're not maintaining the privacy of that piece of trash inside your home. So I think the state, they did a good job making sure to get DNA outside some. Look, I think the familial IgG DNA is fine, and I think it shouldn't be subject to suppression. But what they did was a really good job and just say, hey, let's just make sure. Let's go try to get some of Kohberger's DNA. He was very careful not to provide any, but they got the next best thing, which was his father's, and they were able to rule out 99.9% of the public. And by getting the trash, that avoids any Fourth Amendment issue.
With that being the case, let's talk for a moment about all of the mounting evidence that has come up in this last year against Bryan Kohberger. Obviously, if we're getting that type of a match, like weeding out 99.9% of the population, that in itself seems like a very large slam dunk as far as at least connecting those two sources. Now, beyond that, it doesn't necessarily create someone who saw the crime being committed, but it does put some of his DNA at the actual crime scene itself. There's been arguments that there's other DNA out there that wasn't investigated, that wasn't looked into further, that was at the crime scene, which would make sense. It was kind of a party house. There'd be a lot of DNA there. The fact that this was on the knife sheath underneath the body, is that what makes it so much stronger than any of the other quote unquote DNA that's out there in this house that keeps being thrown out by the defense of making that statement?
I think so, Tony. I mean, obviously, we've come a long way in the past 30 years with DNA. I remember OJ and the jurors thought it was essentially junk science. I mean, now everyone knows how reliable it is. And really, it's the key evidence that puts Bryan Kohberger at the scene, or at least his DNA at the scene. Now, we know his cell phone at least wasn't pinging off the towers at the time of the murder. The white Hyundai Elantra was caught on video, but there's a lot of white Hyundai Elantras, and there was no license plate. Whether the defense is going to argue that it was transferred or contaminated somehow, it's on the knife sheath. We don't have the murder weapon, of course. Pretty strong evidence. Now, we've talked about this case at length. I would have expected there to be a lot more DNA than that. And like you said, there's at least DNA from a couple other unidentified males that have to be ruled out. There's going to be a lot of people coming and going, but I think it's very, very strong evidence, and really one of the two key pieces of well, two other key pieces, three total pieces of evidence that the state hung its hat on in that probable cause affidavit: the DNA, the cell tower evidence, cell site evidence, and of course the Hyundai Elantra, the video surveillance.
Exactly right. There are a lot of pieces of evidence here that are going to be looked into. Obviously, DNA looked at as one of the most strong pieces that they can have out there. But let's talk about the phone records a little bit. Not only do we have the pinging of the towers and the triangulation that's going on, but something that we really have not heard of yet, which will I'm sure come out in the trial, would be the actual data on the phone. What was being texted? What was being looked up? What's in that phone? Are you expecting that we're going to see some pretty strong pieces coming out once this does eventually make it to trial in terms of what data is on that phone?
I do, Tony, and obviously, this case we're subject to a gag order, so
Mhm.
not a whole lot of evidence trickling out since that initial search and arrest warrant. probable cause statement. But there have been some leaks, and one of those leaks are some apparent Instagram direct messages between Kohberger and at least one of the victims. I don't know if those Instagram messages were replied to. Some of the reports were that they were not. But
Mhm.
if you combine that with him apparently going to the restaurant where two of the victims work, you may have some sort of stalking motive here. And look, let's be honest. These were some young women, and I don't know what Bryan Kohberger's interest in them was, but I think that's a good story. That here's some kind of weird, creepy guy who was obsessed with these women, and or at least one of the victims, right? And
Mhm.
that's the basis for the murder. Maybe some jealousy. So I think obviously we know motive isn't an element of the crime, something the prosecution needs to prove, but jurors want to hear why. And why would someone do this? And I think that's a good story. And I think that cell phone evidence, what's actually on Kohberger's phone, will be key.
Yeah, that definitely will be. You have the phone evidence, you have DNA evidence, the behavioral evidence also very interesting. How will that play to the jury when we're talking about some of the information that was out there online, specifically when we're looking at the DeSales uh, project that he was working on, the questions that he was asking of potential criminals to participate, like why did you choose that victim or target over others? Things that were very, very specific, creepily specific when you're talking about trying to investigate criminal behavior, especially after committing the crime. What were you thinking or feeling? Almost trying to create his own guidebook, if in fact he is the killer, as to what he should be feeling and what he should be doing in a crime like this. Is that going to play well to the jury?
I think so. I think it is. And, law enforcement is going to have to explain some of Kohberger's behavior, right? Why was his cell phone turned off on airplane mode, right? At the time of the murders. And I'm going to say, well, look, someone who's very sophisticated that understands that cell tower, that cell site technology, wanted to make sure that he was ahead of it. So everything that he did to avoid, capture the DNA, why there's no murder weapon, right? I mean, here's someone that would take steps to dispose of it, why there's so little DNA, all the things that are atypical, and why, frankly, it took law enforcement so long to find this guy, because he was so careful, one of the most careful defendants that we've certainly covered here on the show. And I think that all tells the story of here's someone that understands the criminal mind, but not just that side, also understands law enforcement and the tools and steps that they take to investigate someone. And that's why he was able to elude capture for so long, and why some of the evidence that we would expect to see in the CSI world just isn't there in this case.
Hey, it's Tony Brueski. If you want more of our interview with our guests, be sure to check out our podcast, Hidden Killers with Tony Brueski. Just search that wherever you download podcasts and press subscribe. Also, you can check out our YouTube channel for the full video version of the interviews as well, under the same name, Hidden Killers with Tony Brueski. Check it out, subscribe, binge, and enjoy. Thanks for watching.